Try that again. Roll call. Estrada.
Present.
Estrada present. Actually, Madam Chair, I don't know if they heard you call the meeting to order, so maybe we should start from the beginning.
Okay, I'll start over. Welcome everyone. Today I'm calling to order the meeting of the Sentencing Guidelines Commission on May 12th, 2022. We're holding a hybrid meeting with some folks here at the Department of Corrections and some folks online pursuant to state law. We're allowed to do that. And we'll start the meeting by just calling the roll.
Roll call. Estrada.
Present.
Estrada present. Hansi.
Present.
Hansi present. Knudsen.
Present.
Knudsen present. Ladd.
Present.
Ladd present. Larkin.
Present.
Larkin present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Morath.
Present.
Morath present. Schnell. Schnell absent. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 9 members present, 1 member absent, 1 seat vacant.
With that, we have a quorum. Just for the record, I ran into Commissioner Schnell. It's been a busy legislative session. He does plan to be here, but he'll be here a bit later in the meeting. So let's move to item 2, which is approval of the agenda. And I would entertain a motion to approve the agenda. I got mine pulled up.
So moved.
Commissioner Moore moves to approve it, and Commissioner Middlebrook seconds. Any discussion on the agenda? Hearing none. Nate, if you could call the vote.
To the Moore motion to approve the agenda, Estrada.
Yes.
Estrada, yes. Hansi.
Yes.
Hansi, yes. Knudsen.
Yes.
Knudsen, yes. Ladd.
Yes.
Ladd, yes. Larkin. Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Schnell. Schnell absent. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
Great. Thank you. The third item on the agenda is to approve the draft minutes from April 14th. Those were sent out to you a week ago, so hopefully you've all had a chance to review them. And I would entertain a motion to approve the minutes.
So moved.
Commissioner Knudsen makes that motion. Do we have a second?
Second.
Commissioner Moore seconds. Any discussion, corrections, anything like that? All right, hearing and seeing none, we'll call the roll on that.
To the Knudsen motion to approve the minutes, Estrada.
I was not present, so I will abstain.
Estrada abstains. Hansi.
Yes.
Hansi, yes. Knudsen.
Yes.
Knudsen, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Schnell. Schnell absent. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the minutes are approved. All right, so we're going to continue. Item 4 is to continue our discussion of sex trafficking and prostitution offenses. And just as a reminder, this is part of the charge that we were given by the legislature to reconsider or think about or comprehensively review sex trafficking and how that's ranked. So we'll move on to, we have a couple of items in front of us, and I'll hand it over to Nate to lead us through those.
Thank you, Madam Chair. So, I was going to say staff, but basically it's me. So if you have anybody to blame, it's me. I took an approach here of basically taking the recommendations that the Central Minnesota Human Trafficking Task Force recommended. We heard from Oli Tweeden, who's the chief of the Stearns County, chief of the Criminal Law Division of the Stearns County Attorney's Office, who explained those recommendations to us at the last meeting. I thought that was very helpful. Those recommendations are found on the bottom of the first page of handout 4A. There's 4 of them. Now there are several recommendations that I'm not mentioning here, and those are recommendations that Mr. Tweeden described as having happened already. Like the commission already took care of that last summer when the legislature made the changes that the task force recommended. So these are the 4 outstanding recommendations. And I could put those on the screen if you think that'd be helpful, Madam Chair.
It's up to you.
Okay, I'll just do it orally if that's okay.
Yeah, that's fine.
So the first for aggravated sex trafficking offenses, to replace the existing modifier, so it's adding 48 months to either first degree or second degree presumptive sentence. If one of the aggravating circumstances is present, and the recommendation is to instead rank aggravated offenses at severity level A, whether it's first or second degree, consistent with the fact that there's only one statutory maximum penalty. So they're just saying, just make one severity level ranking A. Second recommendation is to add sex trafficking to the severe violent offense list. I don't want to talk about that today. I think the commission, as I recall, left off the issue of the severe violent offense list last summer, saying it wanted more information with respect to the new offense that was created last year of child torture. And we asked the commission, do you want to put child torture on the severe violent offense list? And the commission was basically like, let's get some more information. So my thought is that at some future meeting, maybe very soon, I don't know, it depends on what the legislature gives us to work on next month, that we would be adding, we would be looking at the severe violent offense list and looking at, basically my thought is 2 offenses, sex trafficking and child torture, and whether those are the type of offenses that should be added to that list. The third item is to re-rank the prostitution offenses that are now ranked at severity level 9, 5, and 3 on the sex offender grid. So those are ranked now on the standard grid. Rank them as sex offenses on the sex offender grid, severity level B, F, and G, respectively. And the fourth recommendation is to add patrons of prostitution second or subsequent violation, which is a new offense that the legislature created last year. It used to be just a gross misdemeanor. Now it's a felony if it's repeated. To buy sex, as Oli put it, repeat sex buyers it's now a felony crime. And the recommendation is to add that to the list of offenses eligible for permissive consecutive sentences. And I'm also, I'm asking the commission to basically table that also. So basically, we're just looking at recommendations 1 and 3, which are the ranking decisions. So we're looking at whether or not these should be re-ranked as recommended by the Central Minnesota Human Trafficking Task Force. And we did. I will say there were some staff recommendations in these documents. I just want to let you know. I feel like I always have to say this. Like, I'm not under the impression that I'm a member of the Minnesota Sentencing Guidelines Commission. You certainly don't have to follow my recommendation. I put those out there as sort of just something that I basically my impression, what would be appropriate after looking at all this. But I trust that you're all entirely competent to completely ignore my recommendations and just go with what you think is the most appropriate thing. So I don't mean to be stepping on your toes by making recommendations. I hope it is helpful for you, just sort of as a starting point, kind of like the Central Minnesota Human Trafficking Task Force recommendations. So this paper 4A just kind of provides some background. It's really a background paper. It kind of walks through these offenses, defines prostitution, which prostitution really used to be defined as the behavior of the prostitute. And a few years ago, the legislature redefined it to encompass both the behavior of the patron and the prostitute. And I'm going to use those terms, by the way, the patron and prostitute, as opposed to, terms like sex buyer or there's also like for prostitute terms like provider or victim have been used. I think it's certainly appropriate in the context of sex trafficking to refer to that person as the victim. But otherwise, I'm using the statutory terminology of patron and prostitute. I don't mean to offend anybody or pick sides or anything like that. I'm just using the statutory terms. So the first offense that's described is, and there is a footnote that discusses a couple of felony prostitution offenses that we're not dealing with in this discussion, having to do with gross misdemeanor penalties for housing an unrelated minor engaged in prostitution. Maybe that's just a gross misdemeanor, but also increased penalties for prostitution crimes in school or park zones. I think that is ranked on the grid. I'm not dealing with that in this paper at all. And it wasn't part of the Central Minnesota Human Trafficking Task Force recommendations either. So the first offense we're talking about is sex trafficking. Sex trafficking encompasses any of the following acts: soliciting or inducing someone to practice prostitution, promoting the prostitution of an individual, receiving profit known to have been derived from prostitution, or engaging in sex trafficking. So sex trafficking is a separately defined term. It seems to me to have a lot of overlap with those three things that are already enumerated. So I'm not sure exactly why the legislature did that. I think the history was they created those three things. They've been around for a while, kind of like getting at the behavior of a pimp. And then they added the definition of sex trafficking, and then later they added the definition of sex trafficking to this offense. So recruiting someone to aid in that person's prostitution is an example of behavior that's itemized in sex trafficking that maybe isn't covered by one of those three, but there really is a lot of overlap between that fourth bullet and the previous three. The offense does not apply to a prostitute or a patron. Just keeping that in mind. And I mean, it's an interesting thought: does a patron have more culpability if the patron knows that, I'll use the pronoun he, if the patron knows that he is, that the prostitute is actually a sex trafficking victim? There's nothing really in the law that gives you an offense particularly to rank like that. So just pointing that out. So the degrees and the aggravation of sex trafficking is pretty straightforward. So the basic offense is a 20-year felony, second degree. If it's an adult, then it's first degree. I'm sorry, if it's an adult, it's second degree. If the victim is under age 18, then it's first degree. And if any of these four aggravating factors are present, then it's an aggravated offense. Right now, that's got the 48-month modifier. Either the defendant has a prior human trafficking offense conviction, which includes sex trafficking and labor trafficking. A victim suffered bodily harm. The debt, bondage, or forced services lasted over 180 days, or there were multiple victims, which I think in Ann's analysis of the cases, that was pretty common, that there would be multiple victims. That was a pretty common aggravating factor. And just so you know, nothing I'm going to provide really contains much data, with like one exception. Basically, this is just kind of looking at law and policy. And then we got the prostitution offenses. I'll call them prostitution offenses, not counting sex trafficking among them. So it's a misdemeanor for a prostitute to engage in prostitution. It's a gross misdemeanor if it occurs in a public place. It's a gross misdemeanor for a patron to engage in prostitution with an adult, also to hire an adult for prostitution, and it's a repeat offense within 10 years. That's a felony. It's also a 5-year felony for a patron or prostitute to engage in prostitution with a 16 or 17-year-old. Same penalty applies to a patron hiring or offering to hire a 16 or 17-year-old or someone reasonably believed to be a 16 or 17-year-old. And I'm now on page 3, by the way, of the handout 4A. It's a same offense. If it's a 14 or 15-year-old, it's a 10-year felony. So the stat max goes up from 5 years to 10 years. And it's a 20-year felony. So the stat max doubles again if the victim is age 13 or younger. I do have a footnote 3 here, and I'm going to come back to footnote 3 at the very end. If the person is reasonably believed to be 14 or 15, that's a 10-year felony. And if they're reasonably believed to be 13 or younger, that's the 20-year felony. But if they're exactly 13, then it's covered under both the 10-year felony and the 20-year due to what must surely be a legislative drafting error when they changed the age threshold from under 13 to under 14 last year. They just missed subdivision 1B3. So I'm going to ask you to recommend that the legislature fix that. And if you did recommend that, I would give that to the conference committee immediately if that were something you were interested in doing, because they can do that in the conference committee. All right, so overview of offense severity ranking. So the commission obviously is required to assign severity levels to new crimes. We might be doing that next month. We'll see if the legislature has new crimes for us. But for already ranked crimes, you basically have a duty to meet as necessary, as you're doing right now, for the purpose of modifying and improving the sentencing guidelines. So you are certainly authorized to re-rank offenses as you see fit. It's not locked in to just keep it at the ranking you initially decided. The commission bases its severity level ranking decisions in part on the level of harm caused by the offense and the culpability of the offender. Statutory maximums are also considered. That's kind of text that it seems to be in staff materials for many, many years. I don't think it's actually written in the sentencing guidelines or in law, but that's kind of a principle that the commission's applied, looking at level of harm, culpability of the offender, and statutory maximums. You also have the duty, you do have a statutory direction to primarily consider public safety in establishing and modifying good guidelines. Also consider current sentencing and release practices, correctional resources, including but not limited to the capacity of local and state correctional facilities, and the long-term negative impact of crime on the community. Moving on then to page 4 of document 4A, it describes a history of offenses on the sex offender grid. So the sex offender grid was proposed by the commission as a result of a committee that met in 2004. And it looks like they were basically trying to tackle the problem of repeat sex offenders. So the sex offender grid was designed in such a way to really hammer repeat sex offenders. Sex offenses counted more heavily on the sex offender grid. The custody status counted more heavily for sex offenses sentenced on the sex offender grid if the custody offense was also a sex offense. The grid was designed in such a way that for the most serious level, and this is going to be important later, for the most serious level of the crime, the presumptive sentence at criminal history score 6 was equal to the statutory maximum. That's certainly not a goal that the commission has had in writing up the other grids. There's no attempt to put a 30-year statutory maximum for controlled substance crime in the first degree on the grid, for example. And as far as the offenses that were on the grid, that the commission used the terminology in its reports of a sex offense. So I guess that kind of goes without saying, but sex offenses were on the grid. And I think it's important in looking, as far as the history there. So they proposed it in 2005. The legislature actually made some changes to the law as a result of the report. They enacted 609.3455 as a result of the commission's recommendations, which is a law that actually provides for life sentences for some repeat sex offenders or dangerous sex offenders. And that was really following the commission's recommendation, which I didn't realize until I was writing this, that 609.3455 was the result essentially of the commission recommendation. And then they said, okay, propose the sex offender grid again. So they proposed essentially pretty close to the same version in 2006 as they proposed in 2005, and that is the grid that we have today. So the original offenses that were on the sex offender grid were all what the commission considered sex offenses, except for failure to register as a predatory offender. The commission said this isn't a sex offense, but it was concerned about predatory sex offenders that fail to register posing a serious threat to public safety, which I will just say a footnote. One of the people who was on the predatory offender registration task force with me was somebody who was pretty familiar with the literature on sex offenders and repeat sex offenders. Yeah, and he mentioned that people who fail to register as a predatory offender are a high risk to recidivate, not for a sex offense, but for future failures to register as a predatory offender. So I don't know that the statement that predatory sex offenders who fail to register pose a serious threat to public safety is necessarily borne out by current research. But that is what the commission believed in 2005 when it designed the 2004, 2005, and 2006 when it proposed these grids. Not a lot of changes to the offenses since 2009. Sex trafficking was added to the grid. And I will just say, as far as the history goes, if you're concerned about this, the staff proposed, I think it was a 24-month modifier. And then that went to public hearing, and some of the comments from public hearing were, this should really be a sex offense, and it should be more than 24 months. So the commission adopted it as a 48-month modifier. And then afterwards, they looked at, okay, should this be a sex offense? And that's when they added it to the sex offender grid, like later that fall. It didn't go into effect right away in 2010. I don't know why not exactly. It went into effect instead in 2011. It was added to the sex offender grid starting in 2011, and it's where it's currently ranked right now. So it was at 9 and 5, and it went to B and C. In 2019, the commission added a new crime involving surreptitious observation device involving a minor victim and sexual intent. So sexual intent being an element of the crime, it made sense to the commission that that's a sex offense added to the sex offender grid. And then 2021, the legislature just last year created a crime of sexual extortion, and the commission put that on the sex offender grid too. So that's the brief history of the sex offender grid. Not a lot of comings and goings on that grid. So that's the end of the background paper. If there aren't any questions on that, I'll go ahead and move to document 4B.
Any questions? Commissioner Larkin?
Thank you, and I apologize, I don't have my headset. Can you hear me well? All right, I just,
Yeah, we can.
in terms of background, Nate, would you be kind enough just to give us a couple of minutes on the human trafficking task force group that we heard from last week? I'm just wondering, how much deference do we give them? What did they do to come up with these recommendations? Just that sort of information. If you can, if not, that's fine too. I just thought it might be helpful to review that.
Thank you, Madam Chair. We did include the materials in your meeting materials last month where Mr. Tweeden, I thought, did a pretty good job of explaining the rationale. We could always have him back. I mean, it's not like we're asking for a decision today. I'm just kind
No,
of
I
throwing
think
out
she's
directions.
asking, what is that task force, right? Am I correct?
Right,
Commissioner Larkin? Yeah.
How did they come up with these recommendations? I mean, was it a representative group? Did they discuss for a year? I'm just wondering what their process was, so we know how much deference to give them, if any.
I don't think I'm qualified to answer that question.
That's okay, and that's fine. That's fine. I'll take a look back at the materials when it comes time for a vote.
I just wanted to note for the record that Commissioner Schnell is here now. Welcome
Sorry.
to the meeting. No problem.
I can vouch for the fact that Commissioner Chanel's been very busy today.
Yes.
Um,
We'll hear more in your executive director report.
All right, so 4B is talking about one of those two recommendations, the recommendation to rank aggravated sex trafficking at severity level A, as opposed to the 48-month modifier that we now have. And we discussed in the April Commission meeting that most sentencing modifiers apply to a lot of crimes. Like they apply to potentially every crime in the case of attempts, like well, maybe not every crime, but just about every crime you could attempt to do that crime. So that's a very broad modifier. There are some modifiers that are a little more limited, but two modifiers only apply essentially to one class of crimes, and this is one of them. This applies only to first and second degree sex trafficking. It adds the 48 months. The other one is the if you commit a criminal vehicular homicide and you have a prior DWI on your record, then that has a higher statutory maximum penalty. And the commission, rather than ranking that at a higher severity level, has decided to add a modifier instead. And one problem with that is, and I think I probably do need to pull up a slide on this to show you what I mean, is so the statute, the 24409, your charter statute, requires the sentencing guidelines to provide for a range of, to provide for a presumptive fixed sentence. That's what we call the center of the box. That's what the commission thinks is the appropriate sentence for this offense. In addition, the statute requires the commission to provide a discretionary range that the judge can follow without departing from the sentencing guidelines. And that range is defined in statute as 20% above the presumptive fixed sentence and 15% below the presumptive fixed sentence. It used to be a narrower range, and it was equal on both sides, but the legislature decided to give the judges a little more leeway. I think that was after Blakely. Just for, and of course there are some situations where you can't do the 20% up and 15% down. For example, on the sex offenses where I was talking about, where the for the most severe version of the offense, the sex offender grid displays the statutory max as the presumptive sentence. Well, you can't go 20% above the statutory maximum. So the presumptive sentence is both the center of the box and the top of the box, if you will. And likewise, where there's a mandatory minimum of 144 months, for example, for crim sex 1, that's the 144 months is both the center of the box and the bottom of the box. But for most offenses, unless the statutory maximum or a mandatory minimum is getting involved, you do have that 20% range. So let me try to share my screen here. All right. There it is. All right, so I'm going to just show you an example here. I don't know if this was helpful to you to see these bar charts, but let me just explain these bar charts because they'll come up later on in the presentation. So what I was trying to show you with these bar charts, there was some discussion at the last meeting, you'll recall, that we had a table that just presented the presumptive sentences, and we were saying, well, this is higher than that or lower than that. And some people rightly commented, well, hey, that doesn't show us the range, which is pretty important in figuring this out. So what this does is it graphically shows you what the presumptive sentence is here. So let's look at this. What I'm looking at here is figure 2 in the 4B paper, the one on sex trafficking. It's got a black line here at 360 months, and that's because the statutory maximum for aggravated sex trafficking is 30 years. On this one, where it's not aggravated, that black line is at 240 months because the statutory maximum for second degree sex trafficking is 20 years. And then what these bars show you is the range. So here, looks like a criminal history score of 3. The presumptive sentence appears to be 90 months for second degree sex trafficking, which is ranked as a very low C. But what I wanted to show you is this bar here, the second bar in on for aggravated sex trafficking under the current guidelines, the dark blue, that's criminal history score of 1 because you're starting from 0, so it's the second bar in. That is 110 months right there. So what the square on its corner represents is the presumptive sentence. And then what the bar represents is the discretionary range. And it goes above and below. And what you can see here is, and then looking at the next chart over, this is if it were ranked at severity level B, which also is 110 months for criminal history score 1. So it's the same presumptive sentence, right? 110 months, but you can see that the bar is much smaller in the graph to the left, the dark blue, than the graph to the right, the green. So why is that? Like, why would it be a bigger range if it's ranked at severity level B than if it's ranked at severity level C plus a 48-month modifier? And the answer to that question is because severity level B is applying the 20% up, 15% down to the 110 months. Whereas the severity level C plus 48 is adding the 48 months to this over here, the severity level C offense plus 48 months. So because this is a smaller range, 20% and 15% are smaller numbers. And the way the modifiers work is you add the 48 months to the center of the box and to the top of the box and to the bottom of the box, so they all get added. So you end up with a smaller range than you have for this 110 months than you have for this 110 months. So I'm sorry to go into that in so much excruciating detail, but I do think it's important to understand that there's an argument to be made that the modifier, is at least not complying with the spirit of the law to have a 20%, 15% range because it really has a shorter range. All right, so.
Can I just?
Yep.
Well, I mean, it doesn't matter, but like how we look at it in that regard. But you are, I mean, you still, like you're moving the box and then you're creating the range and it's still a 15-20 range. So I guess I'm not sure. I guess I'm not sure that argument holds weight for me. Whether or not it should be ranked versus this way, I think is a separate question, and which I'm totally open to discussing. But I just don't know that particular argument holds a lot of weight because you're still applying the 15 down and 20 up from the new spot, which is 48 months higher than it would have been otherwise.
And I appreciate that. I'm not saying this is necessarily a dispositive argument, but I could see it being significant for some people, so I'm bringing it up. I mean, it's at least worth mentioning. So, and I think the time I devoted to it isn't necessarily commensurate with how important I thought it was. It's more commensurate with how complicated I thought it was.
Yeah, no, it's
complicated. I probably need to spend a little time explaining it.
Hang on, Commissioner Larkin has her hand up.
So I make sure I understand your chart, which is very helpful. Thank you. So if we were to say, all right, instead of 48-month enhancement, we're going to rank it at B, like the next one over, then the presumptive sentence kind of remains the same. The district court just gets a little more leeway in terms of going up or down without having to depart. So it gives the district court judge a little more discretion while keeping the presumptive sentence in line with the current presumptive sentence as modified. So is that a fair way to look at this?
Yes, absolutely, but only for criminal history score of 1. I don't want to give the impression that that's a generally applicable truth, but yes, that is certainly exactly correct for criminal history score of 1 for this offense.
For this offense, okay.
All right,
Commissioner
so.
Moore?
Thank you, Madam Chair. Director Rates, so as I understood the graph here, for all other scores other than criminal history score 1, if it's 2 or greater, the presumptive sentence would be greater on the ranking at severity level B, and then lower slightly if there was 0 criminal history. Is that the correct reading of that? The presumptive sentence?
If maybe if we could just come back to that, because I wanted to just stay on.
Okay, yep.
So I wasn't bringing that up to illustrate the numbers at this point. I was just bringing it up to illustrate the fact that the range was smaller for one 110-month sentence than it was for the other 110-month sentence.
Fair enough.
As far as understanding all the rest of it and how it works, I think there's a lot we could get into. So if we could just come back to that. So I guess what made sense to me is to chop this up into two different questions. One is, should this commission repeal the 48-month modifier and replace it with a ranking to be decided in the second step, or just leave the 48-month modifier in place? And maybe it does make sense to look at that separately. I thought, just kind of from, I guess my bias is just to have things sort of orderly and make sense and be coherent. And so to me, for those two reasons that I just articulated, one being that this is the one of only two single-use modifiers, if you will, which, it just seems like the commission, to be coherent, should just rank it as a separate ranking. And then secondly, because it doesn't quite follow the 20%, 15% range that's in statute. To me, it just made sense to rank it. So I did respect the task force's recommendation in that regard. And if you want to just pause at that point, or we could just go on, because it might make sense to look at.
I think we need to know what the effective ranking is in order to coherently think about whether to change the way that we're doing it. Just to make sure that everybody's clear on all the effects.
Yep.
If that makes it more clear.
Okay, so, and then I'll go back to the bars, so maybe it wasn't,
But I do like the bars, though.
you like the
Yeah,
bars?
they are. That's a nice
I'm-
visual.
I'm glad to hear that.
Very helpful.
Yeah.
I wasn't sure
I
if they
agree.
speak to me.
It was not a waste of time.
Yeah.
Well, I was very satisfied with it when I was done. I will say that. So, so I already explained sort of generally how the bars work. You've got the stat maxes on here. So this is figure 1, and it shows severity level B. So this is nobody's suggesting that we change that, right? Nobody's suggesting that we change what's in purple. I'm just putting that there for reference so you can see what a non-aggravated second degree sex trafficking. So we're talking about, first degree sex trafficking. So we're talking about a child being sex trafficked, but not with any of those aggravating circumstances. So maybe there wasn't any physical injury that was proven, or it didn't happen for a long time, or there was only one child, not multiple children, or there wasn't a criminal history of sex trafficking by the sex trafficker. That's what we're showing here in the purple bars on the left. That's severity level B, no suggestion of changing that. So then we move over to the right and those are two different scenarios for what we could do with, when I say we, I don't think I'm on the commission, I'm just talking about you, but what we could do with the aggravated offenses. So this is where you do have a criminal history of this, or a long period of time, or physical injury, or multiple victims. So the dark blue bar shows the status quo. So this shows how it's currently ranked right now, and what the ranges are that are available. And then the green bar shows how it would be if it were ranked at severity level A. This is the Central Minnesota Human Trafficking Task Force. This is also staff's recommendation. And the reason why we're recommending it, because it's pretty consistent with the status quo. You can see that for most of the offense, so it does get a little bit lower here at criminal history score of, especially criminal history score 3. It does get a little bit lower, but the ranges are broader. So I think in all criminal histories, the breadth of the ranges do give the prosecutor and the sentencing judge discretion, if that's the intended result, to get a pretty similar sentence to what you would get now under the status quo. The difference really is they're a criminal history score of 3. That is markedly lower. And I guess you could say the same at criminal history score 2. That's definitely lower in the green than the blue. So I mean, in a sense, making this decision would give the defendant a break. So I mean, I think there'd be valid reasons if you didn't valid reasons to reject this. But here at criminal history score 0, you would end up with a much taller range that you could sentence the defendant at. So I guess it goes both ways. Again, my bias sort of to keep things coherent and logical. It's very straightforward to just say we're ranking this at severity level A if it's aggravated. That's pretty much how the guidelines do it. Madam Chair, I don't know if you want to discuss that or we can talk about second degree.
I think I'd prefer it if we could just, since second degree is similar, could we just look at both of those and
Sure.
then we can come back and talk about it? Because I think that once we decide on a direction, it's going to apply in both places.
Well, we do it. So the staff's recommendation, maybe I shouldn't say staff because I kind of did this on my own, but my recommendation was,
It's not representative of the full staff.
well,
effectively.
I did bring it up at a staff meeting, but I don't.
Were there dissents?
No, there was no dissent. I mean, everybody seemed to think this kind of approach made sense, but I can't say it was fully staffed. This was
Okay.
pretty much began and ended in my head. So here you see this is a 20-year stat max as opposed to what was it, 25 in the other one. So this is definitely a lower stat max for second degree. And blue again is the status quo. The dark blue is the status quo, where we take the first degree, the second degree penalty, and we add 48 months to it. And then the light blue here on the right is the Central Minnesota Human Trafficking Task Force's recommendation to rank it at severity level A, which you can see is a pretty significant jump for an offense it has a 20-year stat max. It goes up to a 30-year stat max. So I guess you could say, well, that's a pretty significant jump. So it makes sense to do that jump. But I guess in my mind, there were 3 things that caused me to recommend severity level B. One is the statute does make a distinction between adult victims and child victims. And to me, that seems like a rational distinction. And a distinction that the commission may want to preserve in the guidelines by only ranking it at severity level B. And then the other aspect is, I say only in quotes because severity level B still provides for some pretty hefty penalties, including the statutory maximum at the top of the range for people with maximum criminal history scores. So you can get up to 30 years. Even if it's ranked at severity level B, it's just not the presumptive sentence like it would be if it were at severity level A, but it is available in the top of the range. So it's not, I wouldn't call this, soft on sex trafficking by any means. It's pretty uniformly more serious to be ranked at severity level B. Now, again, you've got here at criminal history score 3, it does go down a little bit. But for most of them, the ranges at least encompass the. Oh, I'm sorry, I was off. That's not true. This is severity level 3. So that's up. So they are pretty much all higher. So severity level B is more severe, I think, at every single step. So I thought it was a rational distinction, and I guess the third thing is it's more consistent with the status quo. So those are the consistency with the status quo, the fact that you can still access the high ranges, and the fact that there's a rational distinction between adults and children that I thought the sentencing guidelines could preserve. Now, as you recall from Mr. Tweeden's presentation yesterday, he said this is he called this aggravated first-degree sex trafficking, basically making the argument that because it was under the same subdivision as first-degree sex trafficking, that it was basically the legislature regarded it as one offense. So the structure of the statute is there's a subdivision 1 and then there's a subdivision 1A. No parentheses, just 1A. So in subdivision 1, you have 1 parentheses A and you have 1 parentheses B. 1 parentheses A is first degree sex trafficking. 1 parentheses B is aggravated sex trafficking. This is, again, not necessarily legislative terminology. The legislature's naming of this is not necessarily terribly clear, but to my mind, which is different from Oli's mind, that's aggravated sex trafficking. And 1 parens B applies to 1 parens A and to 1A. So it's pretty much confusing how the legislature's organized the statute. I think it's unique, actually. I don't know of another statute where it's organized in that confusing of a way. So Oli's reading of that is, hey, it's all first degree sex trafficking, so you shouldn't be ranking them differently. Well, the commission has chosen to rank them differently in as much as when aggravated was first put out, it did the 48-month modifier, which applies differently to first and second degree. And I'm suggesting that the commission maintain that distinction by ranking them at B for second degree and A for B for aggravated second degree and A for aggravated first degree. So I guess that's the end of that paper. So if you want to just discuss this, or we can, okay.
Yeah, let's discuss this.
And I'm going to grab some coffee while you're discussing.
Okay, well, I have a question for you, so you're not really off the hook.
Okay.
I was trying to, so I will actually just put my thoughts out there and then open it up for more conversation. But there's something of, I think I sort of initially have similar thinking to Nate in that it feels cleaner to rank the offenses higher since this isn't normally how we handle these offenses. But then there's many criminal history scores where that means it would be a lower sentence. And so that I'm like torn between those two concepts, like the cleanness of that structure versus I'm not here to change any sentences for this offense. And so, but what I couldn't find in our materials, and I probably am just missing it, is sort of what is the typical criminal history score of a person convicted of aggravated sex trafficking. I found the numbers, I found like the sentences, but it's probably just because I didn't have time. I didn't see what like the criminal history scores were, so I was just trying to figure out how it really would play out if we did this re-ranking on the ground. So that might be something we need to look into.
Sure. And like I said, Madam Chair, I'm sorry, this is not a data presentation, so I don't have any of the sentencing practices data. I don't recall if we were specifically given that. We may have. I know that in their materials, the Central Minnesota Human Trafficking Task Force. So one of the changes that the task force made was raising this black line, right? So the statutory maximum was lower than this. So it was all capped at a lower number before last year because
it was exceeded the grid.
Right.
You weren't able to get out to the highest. Yeah. If you were at a criminal history score of 6, you really weren't able to impose a more severe sanction for those people because they were already at their cap. Something like that.
And in their justification for increasing it, they did say that they had cases where people, and I don't know if they specifically said, and I don't know how many cases, it was more of an anecdotal kind of thing, cases where people had lengthy criminal histories, not necessarily sex trafficking criminal histories or even sex offense criminal histories, but just they had been, on the wrong side of the law for a long, long time, and that they weren't getting their full due because the statutory maximum was below the guidelines ranking. And that's now changed. So that is not a data report, but I'm just passing along their anecdotes that they've had that. They've had at least one or maybe multiple cases where they were frustrated by the low statutory maximum.
Thanks. Commissioner Middlebrook.
Thank you, Madam Chair. Just a couple of observations. From the past materials that we got, it looks like there's so few of these aggravated offense convictions. And I suppose from that, what the staff put together that was really helpful about each of those, because there were so few of them, we could probably figure out the criminal history, but we'd need to do some math.
So I
on
was
that. So, but I guess that's one point, is that there's so few of those. And some of these actually are gonna be, they're before they changed the statutory max too. And so those sentences were what a lot of these look like they got statutory max.
Yeah, I'd be surprised if we had any data that was where the offense, we would not have any data that where the offense was committed after September 15th of 2021.
And another thing that observed from some cases coming through, a lot of times on these, they will, and maybe Commissioner Ladd can give more information on that, but it seems like a lot of these really, really serious cases, they're also charging racketeering and then the underlying offenses as well. So some of those, can get way up there on the sentences because of that, as or multiple victims too. I don't know if Commissioner Ladd has got any more perspective on that.
Madam Chair, thank you. I would agree that there is that aspect to it. And I would also just say in looking at the data, which there's not a lot of data out there on these types of cases. In fact, I think if I recall the information that Mr. Tweeden gave us, I think he provided some information. There was like 13 cases about how the sentencings occurred in Stearns, Ramsey, and I think it was either Polk or Polk County, I can't recall, to show what kind of dispositions they had. But one of the things, I actually followed up with Mr. Tweeden about this because I had some questions about some things regarding this. And one of the frustrations I think that they had, and it's an interesting frustration, and again, without a lot of cases for data, it's hard to know like how often would apply. But the 48 months would apply to as an aggravating sentence if one of the four factors are met. But if 3 or 4 of the factors are met, it still is 48. So an offender who does one aggravating factor and an offender who does 2, 3, or 4 of those, they get the same aggravation. And so one of his comments was, that's why it would be better to have it on the grid and to have the range and to be able to move up to toward the top of the box to address those additional aggravations that occur. Because he, again, feeling like a person who has one aggravating factor being treated the same as somebody who commits the same offense and has 2, 3, or 4 of those, they're getting the same consequence and sentence, and there's some disparity in that rationale, and that made some sense too. And I will just say, because I know that I think it was Commissioner Moore perhaps at the last meeting, or I don't know, it was Commissioner Knudsen, somebody had asked about what the County Attorneys Association thought about this presentation and that sort of thing. And at the time, it hadn't been presented to the association, and we did discuss it at our last board meeting. And I would just say that the position that the County Attorneys Association takes on this is they are in favor of any sentences that hold people accountable, and they're not looking for anything that would result in reduction in consequences to these types of crimes, because they're very passionate about sort of prosecuting these and holding people accountable. So I do think that there are some other charges that can come into play that can also affect disposition of these types of cases. So I don't think it's necessarily black and white. It can get to be pretty gray.
Commissioner Middlebrook?
Thank you, Madam Chair. I would note that in a lot of these cases, we do see upward departures. They're pretty frequent as well. And I don't think we didn't get, on the aggravated, it's hard to tell on there if they were upward. We got the mitigated and the downward durational departures, but there are cases that come through that with the upward departures as well.
Commissioner Larkin, and then Commissioner Moore.
Commissioner Middlebrook, that was the question I was going to ask. So if one of these folks gets the enhancement 48 months, that doesn't mean a district court cannot depart beyond that. The 48-month enhancement just becomes the presumptive sentence. and you could do a departure.
Correct.
Is that correct? But
Yes.
Is there a problem though? What I'm imagining is if somebody said, okay, well, there were multiple kids, therefore there's 48-month enhancement. Well, you could conceivably depart based on multiple victims. Can you still depart based on multiple victims if the multiple victims already put you at the 48-month enhancement? It seems like that might be problematic. It's sort of like
Typically
saying,
not.
well, what's that, Commissioner? Or Nate?
My understanding is no, you can't use as a basis for a departure something that's an element of the crime. So
Well, exactly.
that
That's
case-
what I'm thinking. Yeah. So I have a lot of concerns here, and they're consistent with the chairs. I mean, first of all, am I correct? The legislature increased penalties and asked us to take a look at re-ranking. This group has looked at these cases and says the sentences aren't high enough. You need to rank them. But if we do rank them, the effect is to lower the sentences in some cases. And that's not what they were asking for. Although I do like the idea of ranking instead of doing enhancements for consistency. The guidelines are confusing enough. But what concerns me is, what Commissioner Ladd said. I mean, you could have a case with several factors that would justify the 48-month increase. And then that would get you your 48 months, even though you have multiple factors. And then those factors that resulted in the 48-month enhancement have already been accounted for in the sentence. So then you can't do a departure. So that's what's concerning to me about this enhancement method. So I would like to do away with it, but do away with it in a way that does not lower sentences. I think that would be consistent with what the legislature has suggested and the task force has suggested.
Commissioner Middlebrook, oh, wait, I'm sorry. It was Commissioner Moore and then Commissioner Middlebrook.
Thank you, Madam Chair.
Okay.
Well, following up on what you said, Madam Chair, and what Commissioner Larkin said, I just thought it was interesting that the ranking of the second-degree aggravated sex trafficking charges would result in greater sentences, as I read the charts, than the 48-month enhancement for most of the data points. But with the more serious crime, the first degree, you would have at least some reduced sentences. It looks like a criminal history score is 2, 3, and 4, a lower presumptive sentence and a lower range for a more serious crime. And I concur with the concerns about whether or not that was part of the charge here. And I guess I'd be interested in, I can't imagine Mr. Tweeten and the task force representatives would have maybe assumed that would be the consequences of this. Maybe this is one of these unintended consequence things. I agree that there aren't many cases to look at here in terms of data points, but I came into this discussion thinking, like others have said, that, we should do away with the 48-month enhancement. No, I'm not so sure about that, frankly. I'm not sure that's the direction I feel comfortable with.
Commissioner Middlebrook.
Thank you, Madam Chair. I guess when I was looking to, given the ranges are so much greater, as far as lowering sentences, I don't really see, maybe the middle of the box might be a little bit lower, but with the ranges, I don't think any of them are, if I'm looking at this right, for either the first or the second degree.
Yeah, on the first, Madam Chair.
Commissioner Knudsen.
On the first, criminal history 3 is.
That's the most problematic.
That's the most problematic.
Yeah, that's a bit of a drop, but it's, how many is it? Is it lower than the top of the range? I don't know. Not a whole lot. And then 4, but so I'm really only looking at criminal history of 3 and 4 as being a little lower.
I think 2 is as well.
Well, 2 in the middle, 2 for the middle of the criminal history score of 2 in the middle of the box is slightly lower, but the range is the same. I mean, it goes lower, but it's at the top of the range, it looks roughly the same.
Yeah, it's pretty comparable.
Yeah. Yeah, that's, so on, even on 3, you can get to the same presumptive sentence that we had before without a departure, and you can go, but you can't go as high as you could have in the past. You wouldn't be able to. That would be the issue. So that's why for me, partly I was really curious to know what the criminal history scores were, because if this is like these people are, you know, horrific people who come in with long criminal records to begin with, and we're talking about 6s most of the time, then, you know, I'm not as bothered by it. But if they're in that sort of middle range all the time, then it's like, oh, I don't know.
Or zeros, right? Because if
Even
they're,
zeros,
they're
yeah.
coming in with no criminal history, then that's pretty satisfactory.
Right.
But it's just that 3 is,
But there's so few cases too. I mean, it's really, you know, there's so few cases that really anyone could come in on any spot on the grid, really. Because we don't have enough of these cases for this to be a regularly charged and convicted offense. And then there's still quite a bit of mitigation, even though for the small number of cases that we had, there was still quite a bit of mitigation. Although a lot of them did get at least the recommended sentence.
by the way, I should have said there's 2.5 years between each line. That's the scale of this, just in case you didn't get that. So 4 lines equals 10 years.
Is there any, I'm sorry, I just realized I was neglecting the screen. Is there anyone online who wanted to jump in at all? Okay. So I don't know. I mean, what do folks want to do at this point on this topic? Do we want to marinate on it for a meeting, or do people have other thoughts about the direction? Oh, it looks like Commissioner Larkin would like to say something. Please go ahead.
If staff could help us understand this issue of whether the enhancement limits the district court's ability to depart, because that's what's concerning to me. I mean, I would almost rather say, okay, the sentences drop a little bit, but then in a particular case, based on the particular circumstances, the judge has the ability to go much higher than an extra 48 months. And it seems like, first of all, that's consistent with how we do things in the guidelines. And many of the conversations that have been had in my time at the commission are about, we need to pay more attention to the particular circumstances of the defendant. So I'd hate to see a situation where you have a really bad defendant who's, hit all 4 bases for the enhancement, and the district court is limited to 48 months because the district court can't use those enhancement grounds as departure grounds because they've already factored into the sentence. And I don't know, maybe I'm wrong about that, but if that's the way it works, that's what concerns me most about having the enhancement versus a ranking. And it might be for those low-level offenses, I'd be okay saying, well, it drops it a little bit, but in the end, it gives the district court more discretion to use a higher sentence when appropriate.
Yeah, so 2 things. One is I don't know, and maybe Commissioner Midbrook knows, but I don't know that it's impermissible to do an aggravated departure if on the grounds that this offense is more serious than a typical offense. If multiple aggravating circumstances are present and only one is statutorily required. I mean, it seems to me you could say, you could charge it out under the theory that there were multiple victims and then say as an aggravating factor, this victim was personally injured and it happened for more than 180 days. I mean, I I don't know that there's anything impermissible about that, but in answer to maybe this was the first part of your question, I don't think it makes a difference how you get to the presumptive sentence. So if you get to the presumptive sentence through a 48-month modifier, or you get to the presumptive sentence via a ranking, either way, the presumptive sentence is the presumptive sentence. And then it's from that you can depart using the law that governs departures. So I don't think it makes any difference that it's a modifier versus, I don't mean it doesn't make a difference in the presumptive sentence, but legally, I don't think it makes a difference in whether you can depart from it, whether you get there via a modifier or via a ranking.
Commissioner Larkin.
Nate, I like the example you use, because what I'm thinking of is, what if you have a case where there is somebody who is prostituting multiple kids? And, you know, I don't think we'd want to say, oh, well, there were 6 victims, so that qualifies for enhancement 48 months. We might want more than that. But I guess what I'd ask our prosecutor and defense attorney is, I mean, if it were a case with multiple kids, could there not be multiple counts and then an attempt to have consecutive sentences based on each child? I mean, are there other ways to get there? I mean, because we do have the exception, single, you know, you can have multiple sentences, multiple victims if it doesn't unfairly exaggerate the crime.
Commissioner Ladd.
The short answer is I would say yes. And I think that would be a way to go at it. I will just say, I'm saying this on the record, that I would be very disappointed in Commissioner Middlebrook if there wasn't an appeal issue on something where we tried to use something that triggered the 48-month enhancement on a sentence, and then we turn around and use that for the basis for an aggravating factor to get a longer sentence, because that does kind of seem like we're double dipping, using the same element, the same fact, to add more time onto a sentence. And there's something about that doesn't sit square, I think, with consequences. If we were using different factors, I think that would be a fair game for a motion for a departure. But certainly those charging decisions could also come into play as well. And so I think there's a lot of ways to look at this, but ultimately, I do think that if it's on the guidelines without the 48 months, it does allow some of these other things to be triggered in a particular case by filing appropriate motion in that case if it deserves it, and allowing that departure to go forward and be presented to the court in that specific case. I think that there's a lot of legal questions that are probably open and related to trying to use the same factor to aggravate a sentence on top of 48 months. There's something about that doesn't seem like that would be fundamentally fair and legal.
Yeah, I think the question in my mind is, and I think this is what you were saying earlier, is what if the person has all 4, like they meet all 4 factors, and you only need 1 to aggravate the sentence? Is it possible then to have an aggravated departure using one of the other factors? Is that legal when that's also an element of the crime? That's the question that I don't know the answer to. And maybe that's what we need to do our research on. Oh, Anne's got her hand up. Go ahead.
Yeah, well, I got the information on the criminal history scores.
Okay, go ahead.
For the first degree cases, there was a range of criminal history scores: 1 at 0, 2 at 2, and 2 at 6. For the second degree aggravated cases, there was 1 at criminal history score 2, 1 at 5, and 6 at 6. So it seemed to me the most important question is, where is the sentence longer at criminal history scores of 6?
So I'm sorry, can you run through the numbers one more time?
Sure. First degree aggravated, the criminal history scores were, there's 5 cases: 1 at 0, 2 at 2, and 2 at 6. The second degree aggravated, there's 8 cases. We had 1 at criminal history score 2, 1 at 5, and 6 at 6. So overall, there were 8. When you combine the two, all of the between both first and second degree sex trafficking, 8 of the 13 were at criminal history score of 6.
Okay. That's helpful. Thank you. Appreciate it.
Nobody at full.
And then the other thing is when we looked at one of the meetings, we presented you some information at what people were getting. There were two second-degree cases that had total durations of 324 and 700 months, and they got there through consecutive sentencing. So there are some cases getting a long sentences, and they're getting them there from consecutive sentencing.
Okay.
And that's another approach you could take instead of charging it out with multiple victims. If you had another aggravating circumstance, you could just charge each victim's case separately. And you know what I'm saying, allege the aggravating circumstance and just let the consecutive sentences pile up.
That's an issue.
All right. Well, now that we've solved that, I can move on to.
What, were you gonna say something, Commissioner Moore?
Motion to marinate is if that's.
Well, I know.
Seriously, with everything that's been said, I do think a little more study on this would be appropriate just to make sure we're not walking into a problem that's going to need to be solved by some court someplace.
Right. Okay, so we'll marinate. And then if there are, I think we might want to run down this question about aggravated offense, whether or not you could aggravate based on those other factors, if there's multiple factors. But otherwise we'll marinate and we'll think about it again next month. I'm going to tell you right in advance that I'm going to want to marinate on prostitution because that one there's so much in this next section. I came away from it going, oh my God, I don't even know. I was just overwhelmed with information when I was reading it this time around.
Yeah.
But we'll see what you all think. Maybe you all have clarity of mind.
Well, thank you, Madam Chair. I hope I was clear. I'm not saying it wasn't overwhelming though.
Well, I think for me, I'll just tell you right up front, I realized at the end that there's really two issues in this paper. One is whether or not to change repeat patrons, to move that to the sex grid. And the second issue is whether to move child prostitution to the sex grid, and they're two distinct things. And so that's where I was getting, there's different rationales and ideas that go behind each. And that's where I felt like I needed to think about them separately.
Yeah. All right. So as the chair said, the first question is, should prostitution offenses appear on the sex offender grid? So that's the recommendation. The sort of basic recommendation is to move prostitution offenses on the sex offender grid. There's a couple of issues that follow in my mind from that, but the threshold question is, should we just keep things on the standard grid as they are, or move them to the sex offender grid? This is how I thought about it. I was just looking at sexual motivation. Well, obviously it's a sex offense in the sense that sex is involved, right? I mean, it's you're buying sex in these cases, so it would seem to be a sex offense. But then again, it's not criminal behavior. Unlike most sex offenses where the criminal act is illegal, right? I'm sorry, the sex act is illegal. It's not the sex act per se that's illegal if you're dealing with adults, consenting adults, right? The sex act itself is legal, but it's the fact that the sex is for hire that is illegal. So is that a distinction that's important enough to keep it off the sex offender grid? I think is the question. And then there's the question of motivation. Is it motivated by is it sexually motivated, and is there sort of predatory motivations involved? And I think some of these resources that I cited. So this is a Mitchell Hamlin Law Review article note that really goes that analyzes sort of from a legal point of view this article in footnote 6 here, which is a study called Mapping the Demand Sex Buyers in the State of Minnesota. which I will just caution you, if you go to that link and read that study, you will get an eyeful. I mean, it's just words, but it's pretty graphic as far as what it reports about sex trafficking. By the way, as an aside, it did seem like I was wondering why I've never had a prostitution offense when I was a prosecutor in Rice County. Yet they seem to have all these prostitution offenses up in Stearns County. What's going on? It seems to be a regional thing. Like there's these little regional hubs where people go, the patrons go to, or I guess truck stops may be their own little hub, but it does seem to be like a hub situation. So some places you don't see it at all because all your patrons are going somewhere else in that county. So anyway, that's just an aside. But one thing that I did get out of that, specific to the issue of whether patrons of prostitution should go there, it does seem like it does seem like it's the typical patron is motivated by predatory motivations. It seems like, at least that's the impression I came away from that. There's a special concern for sex trafficking victims. So we talked a little bit about the history in 2009. So that's when the legislature created aggravated sex trafficking, and that's when the staff came back and said, let's rank this let's create this 24-month modifier. And some victims came back and said, that's not really enough. Let's make it 48 months. So the commission made it, I don't know if that's what they recommended, but the commission did 48 months instead of 24 at that point. But they tabled the decision on whether to put sex trafficking on the sex offender grid at that time. And it appears to have been out of unintended concern for unintended consequences for victims of sex trafficking, prostituted individuals. I'm sorry, prostitution offenses, not sex trafficking offenses. So if you look at these offenses that I'm calling child prostitution, they can be committed by the prostitute, not just the patron. So if a 17-year-old hires a prostitute, then the prostitute has committed child prostitution. So that's something to keep in mind when you're thinking about sort of the complexities of being a prostitute. Are you a victim? Well, unquestionably, in some cases, the prostitute is a victim. In other cases, the prostitute may be engaging in, a line of work that they've chosen to do, albeit criminal. So it is kind of complicated. So that's a wrinkle there in whether or not to put child prostitution even on the sex offender grid. Although I will say that the clauses are broken out, so you could just take off clause 1 and just do clause 2 and 3, which only apply to patrons, if you were so inclined to do that. That's not what staff ended up recommending. So staff's recommendation was to put them all on the sex offender grid. We two issues on the patrons of prostitution. Just given the motivations and behavior that are typically observed in patrons from reading through that article, it seemed to me to be appropriate to classify these as a sex offense. And being a quote unquote sex offense seemed to be the commission's criterion for putting offenses on the sex offender grid. As far as child prostitution goes, I mean, to me, it's a bit of a no-brainer that if the child's under 16 and it would be a sex offense to have sex with that child, then hiring that child for sex or offering to hire the child for sex would also be a sex offense. It's a little more complicated when the child is technically above the age of consent at age 16 or 17. But to me, the law saying, yes, this child is old enough to, say sexually experiment or something like that without somebody committing a crime is not the same thing as saying that it's okay, or it's not a sex offense if somebody's hiring a 16 or 17-year-old. To me, that's a different category than just maybe sexual experimentation at age 16 or 17. So to me, it seemed reasonable to go along with the Central Minnesota Human Trafficking Task Force recommendations to put these on the sex offender grid. So I looked at that as the threshold question. And then the second section, you could feel free to ignore. Should the commission make further severity distinctions among prostitution offenses? So really my thought here is, as long as we got the hood up, is there any other tinkering we can do here to make things more fair? And there are some different ways of committing this offense, which have a distinction in terms of how either the culpability of the offender, or really in most cases the harm. And those are the two things you look at: the culpability, the harm, and then the stat maxes. Were really what the commission's historically looked at. And so because prostitution can involve so many things, it can involve hiring somebody for sex as well as offering or agreeing to hire somebody for sex, which would typically be an attempt, which would typically be treated less severely. Also, penetration versus contact. Those are treated very differently in the crim sex statutes, but they're treated exactly the same in the in the prostitution statutes. Should there be some kind of distinctions made there? And then the third thing is, what about real children engaging in prostitution versus undercover officers posing as children engaging in prostitution? And that's particularly important if you look at footnote 10. This is a fiscal note we did last year for the age change. It was when the legislature was considering changing the age from under 13 to under 14. So I think it was Ann read the complaints in 50 child prostitution cases that were sentenced in 2019. And 49 of the 50 child prostitution cases sentenced in 2019, there was no child. The child was, a sheriff's deputy with a 5 o'clock shadow. I mean, it wasn't at all involving a real child. It was a sting where a person thought he was hiring a child, and turned out that it wasn't that case at all, which is good news for the children, right? I mean, that wasn't 50 children who were being victimized. I forget the fact pattern in the one case, so from a culpability point of view, right, you could say that the person who's committing who's walking into the sting is just as culpable as the person who actually engages in prostitution with a child. There's no real difference in terms of what they intended to do. Just like an attempt is just as culpable as a completed crime, but we don't punish them the same because the harm is different. And in this case, there's no harm to a child because there was no child. It was just a cop. So I don't mean to be disrespectful to cops. I just mean like obviously the police officers engaged in trying to solve a crime isn't actually being victimized as a child prostitute. What I would ask the commission to consider is whether it makes sense. So regarding those first two distinctions that could possibly be made, the penetration versus contact and hiring versus offering, agreeing, I'm not recommending that you make any distinctions there because it's just really hard to do that. The way that the statute's structured, prostitution, if you read the definition of prostitution, encompasses all of those things in a very few number of words. Hiring, offering, agreeing, penetration, contact is just all bundled up in one sentence. So it's pretty difficult for the commission to make distinctions where the legislature has just lumped everything together. I'm not saying the commission's never done that, but it typically doesn't do that. Thinking of kidnapping, where really aren't separate subdivisions, but the commission has made a distinction on the different forms of kidnapping. But I kind of like to steer away from that based on, again, my bias to make things orderly and neat. But the clause 3 offenses cover people who are believed to be children, whereas the clause 1 and 2 offenses cover children. So it does seem to me that the commission, if it wishes to, could make a distinction here between people who are believed to be children and actual children by ranking clause 3 offenses differently than clause 1 and 2 offenses, which is what I recommend. That's not what the Central Minnesota Human Task Force recommends. And again, that you can feel free to disregard this recommendation. So then the third question is, how should prostitution offenses be ranked on the sex offender grid? Assuming you've agreed with the recommendation that they should be ranked on the sex offender grid. So table 1 looks at the statutory maximums. It compares it on this column here with the crim sex statutory maximums for sort of the analogous crime. If the child's under 14, it looks at the statutory rape offenses for children under 14, both penetration and contact. So those statutory maximums are listed there. I do have 12 to 30 years for penetration because there's a minimum presumptive sentence of 144 months for that offense by statute. So as far as ranking patrons of prostitution, I do think that the severity level G ranking that the task force recommends is fairly consistent with the way it's currently ranked. You can see that in figure 5, which we'll get to later, but I don't have that separately depicted. As far as ranking child prostitution offenses, so I came up with, I was just kind of thinking of different sort of ways of looking at this and how you could rank them. The Central Minnesota Human Task Force seems to be looking at rankings that are fairly consistent with the way the offenses are currently ranked. I take it that's sort of what they were looking at. So I call that option consistency. But unlike the task force's recommendation, I have another option below it for victims who are not actually real children, but just believed to be children. So for option A, which is consistency, I have two choices. One is the first one is the Central Minnesota Human Trafficking Task Force recommendation. The second one is one ranking below that. Option B is the one that staff ultimately ends up recommending. That's to fit again, my bias of kind of making things consistent and the way they ought to be sort of is to fit the statutory maximum, because that's how the sex offender grid was originally designed, is to fit the statutory maximum at the more severe version of every offense on the sex offender grid. So in this case, the more severe version of the offense is the version involving real children. So I try to rank those in such a way that at maximum criminal history, the presumptive sentence equals the stat max. Now you can't do that, unfortunately, with the most severe version of this, because there is no offense. The 25-year stat max isn't on the sex offender grid at criminal history score of 6. It just wasn't designed for a 25-year stat max. So I put it at it kind of fits somewhere in between severity level B and severity level C. I put it at severity level C because at severity level B, I think I can show you this later, but it just kind of breaks the grid at severity level B. And then option C is sort of a thought experiment. Well, what if we rank these like statutory rape? So rank the more severe version like statutory rape involving penetration, the less severe version like statutory rape involving contact. And that only works if the victim is under 16. So for victims who are 16 or 17, I just applied the same rankings that the other two were coming up with, because they were coming up with the same. So let's look at what that looks like here. So here's figure 1. The blue is showing you the status quo. So that's severity level 9. And you'll see something there that you see on the standard grid, you see on the drug offender grid, you don't see on the sex offender grid, which is a straight line. The reason they designed the sex offender grid in such a way that I think they were going for, 2/3 of the stat max at criminal history 4, maybe? I don't know. At some point they wanted to get to 2/3 of the stat max. So it's not a straight line because of what they were trying to do when they made the sex offender grid. But that is sort of what it normally would look like there with the severity level 9. And you can see it's not really getting too close to the stat max of 20 years. I'm sorry, it's 20 years, not 25 years. So option A is the consistency option. That's what the Central Minnesota Human Task Force is recommending. And the reason I don't put that as the best fit is because you can see here at criminal history score of 6, there is no range at all. It's the lowest, the bottom of the range for criminal history score of 6, severity level B, is 255 months. So that's higher than the stat max. So there's really nothing fits that at all. So so you pretty much just have to say the presumptive sentence is 240 months with no range at all. So that seems to go against the guidelines design. So that's why I was recommending criminal history score, severity level C as the best fit. That's the light blue are staff recommendations on this one. And then the brown here is if you were to rank it like penetration in this case, because it's the more serious version. And that would completely be off the grid for 5 and 6. So that's a pretty bad fit. And then figure 2 is presumptive sentences for child prostitution believed to be under age 14. Again, this is if you want to go down the path that I've laid out here for you, where you take it less seriously if it's not a real child, on the grounds that there's less harm. Again, same severity level 9. That's how it's currently ranked. So right now the commission doesn't make that distinction. And I will say when that came out, I was reading through the materials that we presented to you. I was working for you at that time when the clause 3 was invented, and we didn't think there'd be that many clause 3 cases because I guess my rationale was, well, there should be an attempt right now. Clause 3 is basically an attempted child prostitution, but we didn't find any attempts, so we didn't think that it was really going to happen that much, but obviously it happens quite a bit. So option A is one severity level below the task force recommendation. Option B, the best fit, does get you here into some gray squares, which is presumptive stay at criminal history score 0 and 1. That's what the gray squares mean. And there's no range depicted because there's no range shown on the grid for numbers in the gray. And then option C, which would be like statutory rape, but involving contact instead of penetration, would also be ranked as severity level D, which I thought was interesting. All right, so figures 3 and 4 are the mid-age group here, age 14 or 15. This is the current guidelines. You can see there is some presumptive stay at criminal histories 0 through 2. Option A, option A and option B would also have presumptive stays at those criminal histories. And in this case, staff's recommendation is more severe than the Central Minnesota Human Task Force's recommendation. So because we're going with the philosophy that you should try to hit the stat max at the more severe version of the offense. In this case, the stat max would fit very well with severity level E. That's how the guidelines were designed, was for a 10-year stat max at severity level E. And then it would be severity level D if it was like penetration for that age group, statutory rape. Figure 4 shows one step down, severity level G for option A, one step down, severity level F for option B, and 2 steps down, severity level F for option C, like contact. And then finally, we get to the age 16 and 17 age group. The current guidelines have a stay at criminal history 0 through 3 this time. That's also true with option A and option B. And in this case, all the options are the same, all ranking at severity level G. And all the options would be the same here, ranking at severity level H. Now, if you look on your grids, you'll see that severity level H does not have the numbers that are depicted here. But that's just because the only offense that's ranked at severity level H has a very low statutory maximum. So if we had this offense, which has a 5-year statutory maximum, we would be able to print on the grid the actual numbers that belong there, which are the numbers that are on severity level I on your grid. That's what the commission intended when it created severity level H, was basically to clone severity level I, but not have it be a presumptive commitment the whole way across. And then finally, I'm asking the commission to recommend that the legislature fix that drafting error, which I mentioned before. Right now, the hiring for sex of people believed to be 13-year-old children is punishable under 2 different provisions, one with a 20-year statutory maximum and one with a 10-year statutory maximum. I honestly don't know if the cops have tried to pretend to be 13-year-old children since September 15th. And if they have, I don't know how the prosecutors have been charging those cases, because I guess you could go either way. But I think it's just bad legislation to have the same offense covered under 2 different severities of offenses. And I would ask the commission to recommend that the legislature change 13 to 14. And if you were inclined to do that today, like I said, I would write up a letter post haste and get that to the conference committee. So that's all I got there, Madam Chair.
Okay,
A little bit to chew on.
it's a lot. All right, so we have a lot on our agenda, and so what I would like to do is I would like to get some initial reactions from the commission, but I don't want to go more than about 10 minutes on this. It's sort of becoming clear to me that at future meetings, we might just want to tackle sex trafficking at one meeting, come back to prostitution at another meeting, but because we have to marinate on all of it. But so I don't think we're going to solve anything today. That's why I feel comfortable limiting it to 10 minutes today. But I want a more robust discussion in the future. Commissioner Larkin.
Question. So am I understanding that for the youngest kids, if we take the offense from the regular grid and put it on the sex offense grid, the presumptive sentences will go down?
Let me pull it up.
Yeah, thank you. And then while you're doing that, I will say, I do think the kids should be on the sex offender grid. I'm intrigued by Nate's suggestion that there should be a distinction between an actual child victim and a police officer decoy. And I say that because even though the culpability is the same for the defendants, I think the impact on the victim is different. Thank goodness in the case of a police decoy, we don't have an actual child victim. But I think where we do have an actual child victim, we should just be tough. Because, I mean, having been a public defender for so many years, and I'm sure Kathy can, or Commissioner Middlebrook can speak to this, I represented so many kids in child protection, juvenile court, and then in adult court who were sexually abused, had so many problems, and then went on to become sex offenders themselves, and then ended up having that full consequence. So I don't think we can underestimate the impact of sexual assault on children, and when there are opportunities to recognize it and consequence it appropriately, we should do so. All right, so yeah, as I look at those, so blue is what we do now, right?
Yeah, dark blue, yep.
All right, so, and what is light blue?
Light blue would be the staff's idea of the best fit. Can I just make a comment here, Madam Chair?
Sure.
So another approach, and you're right, okay, Judge Larkin, that this would reduce the presumptive sentences for most of these. Now, another approach that would satisfy my mind would be to recommend that the legislature raise the statutory maximum to, what would it be, like 25 years, I think. I'll have to look that up, but if the legislature raised the statutory maximum so it fit severity level B, then I think severity level B would make more sense. And then you could go B and C for the best fit instead of C and D, because you're right. Even this is arguably the biggest problem is is you've got presumptive stays here. It's a very little D. If you look at figure 2, for severity level criminal history score of 0 and 1. So, I mean, you could just rank it at severity level B, go with the, B and C, and then recommend after the fact that the legislature increase the stat max to 300 months to fit the second degree.
Commissioner Larkin?
I'm sorry, to fit severity level.
This is just another broad question. I mean, in my mind, the person who makes the child available to be sexually assaulted is just as culpable as the person who sexually assaults the child. So I wonder, in these cases, and perhaps Commissioner Ladd could address this, are these ever charged as aiding and abetting a sexual assault as opposed to prostituting or sex trafficking angle, which would get you to a higher sentence?
Do you have any input there, Commissioner Ladd?
Well, I mean, I think that would be an option in a particular case. I don't have any information that would indicate that that's how the charging has occurred across the state on these kinds of cases. But again, I think it would be analysis in the charging process that could be looked at.
Commissioner Middlebrook?
Thank you, Madam Chair. Just a couple of questions that I have with regard to that. It seems that on these, they're involving these young children, those cases are being charged as criminal sexual conduct cases. And that seems from the 2009 notes that we got from that commission's meeting where they talked about moving these over to the sex offender grid. One of the things that came up was that those involving children were actually being charged as criminal sexual conduct cases. So, and then you look at the data that we got from February on sentencing practices, we don't have a breakdown on where there were departures or what they were, but on the number of presumptive commits for all of those under 18 years old, there's only 7 cases in a 5-year period. And the rest of them were all obviously probationary sentences. So I was just kind of curious if they actually went to prison on those or not. I mean, that's not very many cases. And under the age 13, which now would be under 14, there was only 1 presumptive commit. So those numbers are not really big prison sentences. I mean, there's not commitments. So that just struck me that maybe we should get some more data on that.
I don't think there are very many under 13 cases. I can't speak to the under 14 cases.
One other question I had is because we switch over to the patrons, because that was, the subsequent offense was a gross misdemeanor until the last round of changes. That's now the felony level.
I don't know if there was a subsequent offense before. I think the distinction was, it was a misdemeanor. And if it was done in a public place, it was a gross misdemeanor. I think that's right. And they made it the base offense a gross misdemeanor and repeat offenses felony, and they got rid of the public place thing.
Right. So we don't have any data on that subsequent felony because it wasn't a felony. I guess I'm confused on that. We don't have any data on that?
No.
So we don't really even know numbers for that particular offense?
We'd have to probably ask the court if we want, if the offense existed at a lower level,
yeah,
they would have no filings anyway.
I think what might be helpful is to look at our fiscal note on that, because I'm sure we looked at that when we were estimating the impact.
True. True. Other broad comments or reactions or things you want to know? For me, I actually still, the minutes from 2010, I think, or what you cited to, still concern me. One of the issues that the commission had at that time was would prostitutes get caught up in this web in a way, people who might be victims themselves get caught up in this, if we change the sentencing? What would be the impact? And I feel like I was looking at the law, and it's really, really difficult to discern the difference between the person who is the prostitute and who is the patron. It's not always very clear to me who's who. And so I wonder if there are groups that we could consult with even today that might give us more information on that. Like if we made a change here, what are the unintended consequences that we're not thinking of?
Yeah, and Madam Chair, if I can, so the law used to be, like I said, the definition of prostitution, the way it read is, that act, prostitution, was committed by the prostitute, and then it was a different act to be the patron.
Right.
And under that scheme, Clause 1 offenses were committed by the prostitute. Clause 2 offenses were committed by the patron. So it's pretty straightforward. And it's still the case that only the patron can commit Clause 2 offenses. But since they redefined prostitution, Clause 2 is really redundant now, because prostitution now covers both the prostitute and the patron. So
Right.
Clause 1 essentially covers everything. But if you wanted to, you could sort of keep Clause 1 offenses on the standard grid, put Clause 2 offenses on the sex offender grid, since they only apply to patrons, and put, what I would recommend, put Clause 3 offenses one step below that. So it would definitely make things more complicated, but it would be rational. But the problem is patrons can be in Clause 1, but only prostitutes can be in Clause 1. Patrons are always in Clause 2 and 3 only.
Well, I need you to parse the statute for me, because I don't even see it that clearly. So, I mean, I think number one, it would be helpful if we also, that when we put prostitution back on the agenda, I think we need the statutes in our packet so that we
Sorry
can.
about that.
I looked them up, and then I'm like, I am looking at the right statutes, right? I think. I mean, this is just, I don't deal with these statutes very often, so I'm not even, I just don't want to come at this without information. But yeah, I'm concerned about treating the two the same way, or whether we should consider treating the two differently. But I also want input. Like, this is not, I'm not an expert on prostitution cases. So I feel like maybe some of the groups that were here in 2010 on this issue, we could ask them to come back and talk to us some more. Or I don't know if there's new groups out there that have been working. I mean, you've been working on the sex offender task force and a couple of those different arenas. And you've probably been working with folks who actually work in this arena. So perhaps you can make some contacts for us that might be able to bring some information into it. I'm just concerned about unintended consequences.
Yeah, that organization, the Advocates for Human Rights, is not an organization I am familiar with, so I don't know if it still exists.
Okay.
But that seemed to be the organization that was very, very, very much involved in this whole process.
All right, any other comments or questions or direction that we want to give to staff before we put this on the marinating spot?
I just have one comment.
Yeah.
And it's a little bit, thank you, it's a little bit a different position than Commissioner Larkin, but I do see the value really in not making the distinction between a real child versus the undercover folks, because there's very few things that law enforcement can do from a public safety perspective to be proactive and jump in front of it, waiting for a victim, an actual victim, to be victimized. So the idea that everything in the elements of the crime are the same, except when the door is open, there's a law enforcement officer standing there versus an 8-year-old child. I don't see the distinction there, and I think anything that we could do by way of having those things have those same consequences, because the person went there with the intention to do the very thing that they were able to do because of who answered the door. I don't see that the culpability on that is different. And I appreciate very much that we didn't have a child who was actually victimized per se, but I don't find the need to sort of parse those two things out. And so I'm kind of the mindset right now. And again, any data that we would have to show sort of how those numbers work would be good. But I think from a public safety perspective, we want law enforcement to be in front of those things and hold people accountable.
Commissioner Morath and then Commissioner Larkin.
And I would agree from the public safety point, it's really difficult, particularly without having the data. But one thought is if you reverse that scenario and are assigning the same sentencing to whether or not there was a true or actual child victim, positioning yourself as that primary or secondary victim as the family and whatnot, maybe interpreting that as, yes, but my child was actually victimized. So if you reverse it, you could see where it might make sense to have that heightened sentence in this with a real victim.
Commissioner Larkin and then Commissioner Moore.
And I should just clarify, I think the offender's culpability is the same in either scenario. I think the consequence should be worse if there is actually a child victim. That's not saying I think we should reduce the consequences. It's like we should start where we are and then have a harsher consequence if there is a child victim. I'm in no way suggesting there's reduced culpability on the part of the offender.
Commissioner Moore.
Thank you, Madam Chair. I'm wondering if in this discussion, it would be helpful to get some input from law enforcement representatives such as the Internet Crimes Against Children Task Force. When I was county attorney, those were the people that I was working with on some of these types of cases. And I suspect they would be saying a lot of the things that Commissioner Ladd was just saying about the role of undercover law enforcement and dealing with, people who are looking for children as potential victims. So it'd be interesting to get more input from the outside, and the group that was speaking in 2009 too, that talked about those unintended consequences, advocates for human rights. I'd like to hear from them if possible.
And what was the group that you said again? I'm sorry.
About the Internet Crimes Against Children Task Force.
Okay.
Commissioner Ladd might to be more familiar. It's been a few years for me.
Yeah, the acronym is ICAC.
ICAC, yeah.
Yeah.
All right, thank you. Did we cover everybody? Did everybody get to? Yes, Commissioner Knudsen.
I think it's gonna get really messy and sticky if the statute doesn't break out these distinctions of the crime. And I don't know that the statute in these areas do, so like you had mentioned, it'd be nice to have the statute in front of us next time. That would be helpful.
Yeah.
But boy, I would hesitate to try to start making the distinctions and adding different distinctions to the statute where the statute doesn't make the distinction at all. That's going to be messy.
Yep. Okay. All right. Yeah, I think that part of what we'll want to do as we take this up, there's a lot of different issues in this paper, and we might just want to try to break it down as small as we can so that we can see each little bite, figure out what the different considerations are, and then get big picture, like what happens if we change this and this, how does the puzzle fit together? But we will take this up again in the future, most likely taking up the aggravated sex trafficking first, because I think we might be a little closer on that one, and then moving to this at a separate meeting instead of trying to do it all at once. Okay, thank you for the discussion today. Let's move on to item number 5. Easy. Let's do this one. Item 5. Technical modification.
I'm going to give you all a break here.
Okay.
And, let Jill present this one.
me to describe it as it will take for Nate to bring it up on stage. This is before the commission today as a discussion item. And what we have here is a typo in the guidelines under one of the factors for departure, where the word is does not belong. The error occurred during a rewrite in 2012 when the word was stricken and then reinserted accidentally. Staff recommends removing the stray word as shown under suggested correction. And staff will bring it back next month for a vote, and then it will go to the public hearing in July.
Any questions? Thank you very much.
Thank you.
I think you can blame me because I think I was the director at the time.
If we start blaming people for things, that's not a good road to go down.
Oh, no, that's really not a good precedent to set. You're right. All right. And no questions on that one? Okay, so that'll be a simple one that we can vote on next month.
Or not.
Unless anybody wants to vote to suspend the rules or move to suspend the rules so that we can vote on it and get it knocked off the list today. That would be the other way to go.
I'd move that.
Well, one thing, can I just say one thing?
Yeah.
As far as I know, the legislature hasn't actually done anything yet that the commission would have to take action on. And it's foreseeable that in the next week and a half, they won't do anything that the commission will have to take action on. I don't know, it's possible. So Jill, correct me if I'm wrong, but I don't think we have anything else for a public hearing. So it's possible there won't even be a public hearing, but for changing this is. So maybe we want to just put this in our pocket and hold off on it. Because if we're not doing a public hearing in July, we could just skip it. But you're right, we wouldn't have to put this to a public hearing.
We don't have to put it to a public hearing. Yeah. Anyway, what do you guys want to do?
I'd move the waiver.
So we have a motion to suspend the rules. Is there a second on that one?
Second.
Middlebrook, Canute, either one of you, both of you second that one. Do we want to make it all one motion to suspend the rules and approve so that we can do it all at once so that Nate doesn't have to read our names twice? Or
I would take.
That's
that
what you
as
did
a
move.
friendly amendment. Yeah,
Right,
that's
yeah.
what I meant.
Any objections to that with the seconds? Okay, all right, so the motion is to suspend the rules to require the second reading and to approve this this change, this technical change that's drafted. Does that capture it?
Sure, and this would be effective August 1st of 2021, or 2022, whatever year it is.
Great.
Okay.
All right, any questions? Any discussion on the motion? Hearing none, we will go ahead and vote on it.
To the Schnell motion to suspend the rules and adopt the staff recommendation in agenda item 5, effective August 1st of 2021. Estrada? 2022. Sorry. I wrote it down as 2020. That's why I read it twice. I'm sorry.
Yes.
Estrada, yes. Hansen?
Yes.
Hansi, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Larkin? Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Marath?
Yes.
Marath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes,
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
with that, the motion is approved unanimously. Thank you. All right, it's nice to get something done. However small. This is how I work on my own personal to-do list, just knock those things off. Okay, number 6 is possible amendments to the commission's demographic impact statement. So it's on as an action item today because we did actually look at this last month, or we looked at it 2 months ago. Actually, we didn't have the time to look at it a second time last month. I'll turn it over to you, Nate, whenever you're ready.
Thanks, Madam Chair. And I will say I had thought about bringing a little bit more to the commission in terms of streamlining the process a little bit. Right now, the process does require me to send out draft demographic impact statements to commission members in advance, commission members who are interested in being part of the review process, which the problem with that is it can slow things down a little bit, and some of these can be very time sensitive, like coming up for a vote in a committee or sometimes on the floor, depending on just how things work out, both in terms of when we got the original fiscal note and when we had time to do the demographic impact statement. Didn't run into a problem with that this year. I think the two commission members who were interested in making comments for demographic impact statements were very responsive, even getting their comments back quickly, but I guess I'd be interested in whether the commission were interested in making that more of an after the fact thing than a before thing to slow it down. But and the other thing is I appreciate maybe some more explicit authority to not do a demographic impact statement on a dead bill. If we got a fiscal note on a bill, but it's clear there's no action, such as happened this year with the child pornography bill, where we got a fiscal note on it, but it never got a hearing, and it's essentially dead as far as I can tell. We didn't do a fiscal note. I hope I'm not violating the policy by not doing demographic impact statements in those cases. I'm sorry, we did do a fiscal note, but we didn't do a demographic impact statement. But that's not before you today. What's before you today are changes that were proposed, I believe, by Commissioner Knudsen, that dealt with the distribution of these. So you can see there's some conforming changes here at the bottom of page 1 of the demographic impact statement, and the top of page 2. Just noting that this is not exactly the same as the fiscal note process. It is its own process. And then down here at the bottom of page 3, we have the distribution. So the distribution, instead of being to the legislature, it's made clear that it's, which from the language that we changed earlier implies that it's to the chairs of the committees only, now specifies that it's to the chairs and ranking minority members of the standing committees in the House of Representatives and the Senate with primary jurisdiction over felony crime. So that's right now the Senate Public Safety and Judiciary Committee and the House Public Safety Committee, Public Safety and Criminal Justice Reform Committee. So those committee names can change with different legislative sessions, but by making it the chairs and ranking minority members, you get the demographic impact statement, at least in the hands of people of two different parties. It seems like a reasonable way to do it to me. And then also to the chief House and Senate authors of the bill and its companion. And this was brought up to me by an author of a bill, Representative Pinto, who said, boy, it would have been nice if I had known that there was a demographic impact statement on my bill. So that's why that's in there. And if applicable, to the legislator who requested the demographic impact statement. So that's in a case where the legislature specifically requests a demographic impact statement, which is one of the ways we can do demographic impact statements, not just if it meets the significance threshold. And we had a fiscal note. And then on the related information, I just made the superseding clause a little bit more generic. So those are the changes that I think are consistent with what the commission had previously intended and what we had previously discussed.
Commissioner Knudsen?
Oh, Nate, what do you want to do with the two issues you just raised, though?
Well, I mean, I guess if those are,
because I don't think the commission wants you to be spending time doing demographic impact statements on the bills that aren't going anywhere. And if it says that we have to do it in every bill that's that's dumped in the hopper, you don't want to do that.
Yeah, I honestly spend so much time on that stuff with prostitution and sex trafficking. I didn't have time to even draft this document in time to send it out to the commission. So I don't know. I don't have specific language ready for you today.
No, you may not have today, but maybe we just wanted to just take the whole thing up next meeting with some additional language that clarifies those two issues you brought up.
I mean, I think, Madam Chair, if there's a sense that the commission would be interested in making at least one or both of those changes, I'd be happy to draft it up. And I mean, the other issue is, to me, it's a philosophical issue in terms of the board governance model, right? Like, you're the board, I'm the executive officer. Your job is oversight. My job is to execute. So you tell me what you want to do and I do it. So this is a little bit different from the board governance model, where it actually has the board as part of the executing process, actually. Like basically it should be, you tell me how to do a demographic impact statement. I do it the way you tell me to do it. I do it wrong, you fire me, or discipline me or whatever
That's
you
all
want
you
to
have
do.
to do.
That's all. So you have other options, but that's one of them. So, but what I'm saying is that's sort of the classical board governance model, whereas this is getting the commission involved, but maybe some of the commission members who have been involved in that process in the past would like to speak about how they thought it was very useful. My concern isn't getting the commission members involved. It's just the timeline of it. I mean, some of these things really have to go fast, or they're just, it's just a piece of paper. I mean, for it to be actually useful to the legislature, it has to be there before the decision is made.
Commissioner Knudsen.
Well, I would just recommend that you provide a copy of the demographic impact statement that you draft and prepare and send to the legislature to all the commission members. Comments and feedbacks, whatever, but submitting them and getting them over to the legislature, not contingent on receiving them, waiting for responses from the commission members. And you could give a date that you're going to get it to them, or you've already sent it to them, or whatever, but at least you provide it to all the commission members at the time that you provide it to the legislature.
Right.
Yeah, I was thinking the same thing, that it's like if you've been asked to do a demographic impact statement and the vote is tomorrow, then it's ridiculous to have us hold that up because you have to give us 3 days to respond, but if you sent it and said, if anyone has time to look at this in the next 2 hours, I have to send it out by X in order to get it to the people who need it in time, then, if we respond in 2 hours, we respond in 2 hours. But like, the more important thing is that the data gets over to the legislature, I think. I don't know, Commissioner Middlebrook, you had your hand up.
Thank you, Madam Chair. I think you do that, Nate. You do say if you need it before the 3 days are up. You're pretty good on those emails, how fast you need them back. And my other question was whether, sometimes I know you do get input that, or, just something clarifying or a question comes up, and it seems like that is good for you to get that, but
And I agree with that, both of those points. One is, this year, you were very responsive, and as was the other commission member, in turning it around when we needed to. And it was not a problem this session. It could be. I mean, it's given that there's a 3-day time period in there, and 3 business days, I think. That could be a problem.
I think you could change that language to give yourself the flexibility to tell it to give us a shorter deadline. I also questioned the line before that, which was you have to forward it to the requesting members not later than 7 days before it must be submitted to the legislature. So is that us?
I don't know.
I don't even understand that line.
I don't know if I understood it either.
I'll be honest. So it just feels like, I'd be okay if you wanted to work on that issue, as well as the issue of if the bill, isn't getting scheduled for a hearing, because I think you always have to do that triage on the fiscal notes as well. And if you tend to prioritize fiscal notes where there's actually a hearing coming up, and I think that you should be doing the same here. So I'd be okay with that, but I also have an edit if we're going to take this back.
Okay.
I have an edit to the language here.
Well, if we're going to take it back, I would welcome the opportunity to take that back, and maybe I could just consider anybody's edits that they'd like to send me.
Yeah.
You know, this was mostly the work of a previous commission member who I think added a lot. I mean, that the whole, you know, Minnesota Rule of Evidence 702, you know, I thought it was a bit of a head scratcher first, but it's kind of grown on me as far as just having a you know, an objective standard by which you can or cannot issue a demographic impact statement. So, yeah, I not to kick the can down the road, but I mean, there is no urgency on this.
There's no urgency on it yet.
So yeah, if we want to do it right, if you will, I'll be happy to take this back, put in a little more flexibility on the timeline and commission oversight and any other edits you want to send me, and the flexibility not to do dead bills.
Yeah.
All right.
Just bring it in line with reality,
Thank you, Madam
the
Chair.
reality of the session.
Right.
Okay. So that takes us up to item 7, which is planning for the custody status roundtable. Who's gonna, I don't know who's leading this one. Is that you again?
Well, yeah, I mean, it's, I don't know what you want to do with it. We've basically given you some documents that describe some of the logistical considerations and a draft invitation, but I guess I was hoping that, you know, you could give some guidance, Madam Chair, on how you'd like to proceed. We have not, we basically described how it was done in 2013. I think we could certainly do it at this room. I mean, I think this is a very good room for it. It's a good sized room. We could probably fit in everybody we needed to. You were saying you thought it'd be good to have people here in person, especially members of the commission here in person.
Yep.
We have a number of different groups: community and victim, legislative, judicial, executive branch, academics, human rights, public defenders, peace officers, police, sheriffs, prosecutors. If there's anybody in that table that you think we're missing as far as giving invitations, we'd like to know. If there are.
Well, we're not going to invite that whole table.
Okay. Well, who?
We can't.
Yeah.
Like we have to limit the number. This is a round table, which means that everybody is at the table. There's already 11 of us here. You know, I wouldn't want to more than double our commission. I think we have to sort of hone in on who. I mean, everybody can be invited to submit comments, of course. That is not an impediment at all. But the idea of a roundtable and the way it worked in the past is that it's really a give and take. Like we would have somebody else facilitating, so that I'm just a member of the commission and not leading the discussion. And so someone else would be facilitating the discussion, and the idea is sort of to have a conversation with some of our stakeholders to help us sort of figure out, well, what are the options? What are different ways that we could sort of resolve this problem, or resolve this issue of what policy options could we come to, or what are the concerns? I'm not exactly sure, you know, what the questions are that the facilitator might walk us through, but that requires a smaller number of people at a table and back and forth.
Do you have a facilitator in mind, Madam Chair?
Commissioner Larkin, did you have a comment there? Go ahead.
I have a question. Hearing you describe that, I just find myself asking, isn't that what we're here to do? I mean, we've got a commission that represents all relevant stakeholders. It seems odd to me that we would say, okay, well, we want to bring in somebody else to tell us what to do here. I mean, isn't it our job to figure out what to do? And I thought when Chair Dietzen did this in the past, it was more like some suggestions were sent out to stakeholders and they were asked to weigh in on the various suggestions. And I mean, I understand that. That's sort of like winnowing down the options before a public hearing. But I guess I question why we would sort of turn our responsibilities over to another group of people.
Well, remember, it's not turning responsibility over, and under Chair Edblad, it was this was the roundtable model that occurred. And it wasn't about turning over responsibility. It was about inviting more voices in to help us come up with a solution. We're a little deadlocked. And so I think it would be helpful to have some more voices at the table to try to work through some of these issues and continue to get outside input as to what the priorities are and what possible options are. We may not end up with a policy at the end of that roundtable, but we may end up with like a better understanding of priorities, and that could help us craft a policy. So that's the difference. And the model that occurred where more recently the commission sent out a laundry list of ideas and asked for input was a public hearing, which we had, but that didn't really allow for a lot of give and take. So that's the difference, is that we are at a table, trying to be able to do some give and take without the high stakes of having to make a decision at the end of that process. So it's really that's the intent. It's for it to be more interactive and in line with Commissioner Schnell's desire to engage stakeholders more. It's a more engaging process, I think. Commissioner Larkin.
Then that's great, but to say we want a more engaging process and then say we're going to limit who's at the table. I mean, my concern is I want to hear all sides of the issue. It just seems so much that all the studies and that everything's presented to this group in terms of we need to reduce sentences, we need to have these reforms. And there's another side to all this, and it doesn't seem that we're often presented with that other side. I mean, I read papers and I see people citing studies that say other things, and those studies are never cited to this group. It always seems to be this very specific agenda driven, we want to get to this goal. And so if we are going to do this exercise of having a roundtable where we, hope to enlighten ourselves and the public, I just sincerely hope that we're going to hear all sides of the issues and not just, have a few people come in and tell us why to reduce sentences, which is what usually happens.
Right, and I think to achieve that, we need recommendations for who do you think needs to be at this table? Commissioner Schnell.
Madam Chair, for me, I think as I mentioned when I made the motion to do this, it was really about deep levels of engagement. And the problem is that I think that there is, how we winnow this down, how we identify people who can give voice to this. It really is about how do you have a more engaged conversation with a range of stakeholders. I mean, a range of stakeholders, and I take a bit of exception to the fact that it's all just about, reducing sentences and so forth. I get that may be the feeling. At the end of the day, I think that part of some of the discussion here is around what actually is going to make a difference and what may work. And I think it is the full range of conversation that I do believe needs to happen. But I'm not suggesting, I certainly never anticipated, and I don't hear the chair or anyone else suggesting that it's going to be packed with a group of people who are going to take one view. But how do we have conversations about what is going to make meaningful differences and change and achieve the state's other objectives, including retribution, deterrence, and the other kinds of factors that certainly are at stake. So, I want to be clear about the fact that I do think that it's one thing to have a whole, I took a little bit of a shot around, we got on the email side, we got a lot of emails that were, where people had just typed in their information and sent it, and granted, they weighed in. But the goal was here, not a vote. We could have done a vote that day, and we would likely have a different policy proposal going forward, or at least that would have gone to the legislature. we don't. And ultimately it is around having more engagement and looking at this from the broadest range of perspectives and being able to have conversations beyond just the members of this group that I think as you and many other members of the commission have pointed out, may have some levels of philosophical differences, but to really kind of, I get beyond or dig deeper into the layers around that is really what I would hope could come from this type of a roundtable discussion.
And I want to add to that, so for instance, when I think about who I'd like to invite to the table, I would like to invite legislators to the table. This is an issue that goes back and forth between us and them. And there's been a lot of rhetoric about the topic, but not a lot of engagement with the actual information underneath it. So I'd really like to have, I mean, we can't guarantee legislators will come, but I'd like them to be invited to participate with us in the roundtable and to actually grapple with this issue directly. So, you know, I would recommend that we would put an invite out to the chairs of the public safety committees in the House and the Senate, and, you know, and either ask that they or designee, whoever they designate, would come and join us at the table. That'd be like one group that I think we want to engage with directly.
Madam Chair.
Commissioner Estrada.
Thank you. I also saw this as an opportunity to kind of learn a little bit more. I know, Judge Larkin, you've asked for some of the data and what different agencies are doing. And though I am in constant communication with MACAC and letting them know what we're talking about and getting feedback and constant emails back and forth, you know, the president of MACAC or a member who is sitting on that board may be able to answer some of the questions that this commission has in regards to what's being done in other counties that I necessarily don't work in, and I don't have that access, like the real access to. So I see the roundtable also as an opportunity for this commission to continue to learn about what's being done, whether it's, you know, MACAC or, you know, what law enforcement's doing, or, you know, certain organizations and things of that sort. And I agree, it should be open. I don't think that it should be one-sided. I think that we need to hear all perspectives.
Other comments or input on, you know, particular viewpoints that it would be helpful to have at the roundtable, or particular groups or roles, I guess would be another way to say it. Oh, I'm sorry, Judge Larkin.
And when do we anticipate doing this roundtable?
We had, the suggestion here is for July 28th. It's a regularly scheduled meeting. It would normally be the meeting where we'd be approving the rankings that we did from the legislative sessions after the public hearing that occurs in July. So we probably won't have anything to do. But that, I'm going to leave that for the executive director's report. Yeah. Commissioner Middlebrook.
Thank you, Madam Chair. One other community group I would suggest adding to consider is the Minnesota Justice Research Center.
Yeah, I thought of that too. Any other input? Commissioner Ladd.
Thank you. I think it would be particularly important to have some law enforcement folks here, given that we've got that vacancy in that particular position right now, and I don't know if we're gonna have that spot filled by then. I mean, I think we had the victim's position was vacant at one point when we had one of our either meetings or public hearings. I just do think that those groups came to our public hearing, provided that information. So whether or not we've got that spot, the governor's got that spot filled or not. I just think it would be really important to have, law enforcement at the table as well. Whoever that would be, I'm not going to suggest any particular group because there's lots of associations. But I do think given that we got that stakeholder on the commission and it's currently vacant, I think it's really important to have that represented at any kind of discussion we're having.
Yeah, I agree with you. Is there like any, I guess the question is, there's so many groups. Is there any, how many people should we invite from that quarter? And is there any group that like fits better than another? I just don't actually know the answer to that one. Maybe no one else does either. Commissioner Larkin?
I don't know if he would agree to it, but perhaps we could ask former Commander Omari from Ramsey County to appear on behalf of law enforcement. I mean, he was always very good about sort of voicing what it's like to be investigating these crimes and dealing with the victims on the scene. So, and he's aware of our work. It might be worth inviting him to come to the roundtable.
Okay, yeah.
Madam Chair, maybe
Commissioner-
perhaps
No.
perhaps like, with some of the groups, perhaps the three different law enforcement associations may want to collaborate on trying to identify a representative, or the County Attorneys Association may want, another representative or somebody. It could be, any number of, especially when we think about the people who spoke really on both sides of the issue too, making sure that the representative voice is there. So I do think that, there certainly could be an approach, academic institutions or organizations like that, is there a way that there could be some collaboration around who might represent some of those groups more broadly?
I was actually having a very similar thought. I think that might be a good idea to sort of reach out and ask if they could collaborate on identifying somebody. And then of course, we'll have a portion of the day that is public comment. So I would imagine people might listen in to the roundtable, and then they might want to, spend a minute or two putting in their perspective on maybe things we said or adding to it. But then also, people can submit written comments as well. So there's no preclusion of ideas here. I don't want to do that. So even if not all law enforcement associations are at the table, they'd have an opportunity to directly provide input.
One other question, Madam Chair.
Yeah.
Just will we provide one of the advantages that many of us had that a lot of folks don't? Some people who are system practitioners certainly have a lot more awareness of the issue. I certainly learned a lot through this process. But is there a way to kind of distill some of the range of information we had so that it helps focus that conversation?
Yeah, I think we definitely have to. With the last roundtable the commission did, the beginning portion was sort of a presentation of information that was on the drug issue. It was a presentation on information about drug sentencing. And that just provided that sort of baseline of information so that everybody had the same sort of baseline starting off. I think we would want to do something similar here where we'd sort of distill down some of the information that we've had. We've gone through a lot, but sort of what are the high points of what we've gone through in the past, so everybody has that, and we'd want our facilitator to have that too, and then kind of move from there. Yeah, I think that's really smart. So maybe we could, does anyone have any more comments or input on who or how? Commissioner Knudsen?
Well, there are a lot of emails ginned up in response to what we were doing, so maybe a representative from the group that instituted that. But I'm not interested really, as a member of the commission, in in getting people's opinions. I want to make sure they're educated on the issue
Yeah.
and that they're going to help us solve the problem, rather than just say, don't do this. Well, we have to do something. And so we need your help in understanding this because of the changes that we've made and the history of this issue up to this point. That's why we're here and that's why we're struggling with this issue. And we've
Yeah.
identified these options, and some of this is in this invite already. We've identified these options, but we haven't found consensus on these options yet. So are there other ways to look at this issue or to resolve this issue? And that's what we're looking for. We're looking for your insight and your suggestions to solve the half-point custody status point dilemma.
Madam Chair, I don't know if it's ever been brought up, but my understanding of where those emails came from was there's a conservative think tank called the Center for the American Experiment, and I think they had some articles critical of some of the proposals. I think particularly the proposal to repeal it, and they had a take action link, and if you clicked on the link, you got to the web form where you could send in the email. So are you suggesting somebody from the Center for the American Experiment?
Yes.
But I like what you said about, I mean, Judge Knudsen, the way you just described what we want to achieve here is exactly the way I was envisioning this roundtable too. I think we just put that right in the invite.
Yeah.
Make it very explicit, like this is why we have invited you to come here. I mean, we could consider whether to also send some of the data and information out with the invite to give them a chance to review it ahead of time. I think we would still want to go over it at least briefly within the context of the meeting, but maybe if they even have it ahead of time, we'll get better ideas. What do you think?
Definitely.
Yeah, okay. Okay.
And if it's, just to let you know, full disclosure here, I'm out of town on that day. So.
Oh, you are? Oh, that's horrible. Well, you shouldn't have been. It should have been on your calendar. It should have been your number one priority. I'm hurt. I'm hurt. Well, yeah, hopefully there are, well, I mean, if that means we need somebody else from the district court, maybe that means we need to invite another district court judge, since you won't be able to be here that day.
Maybe Chief Judge Mark
Oh,
on the Omari.
Judge Mark loved to come back. Let's make him do it. Okay. All right, anything else? So I think we can work on the invite to add in some of these concepts. Maybe we could take a run at pulling together some brief information that could be sent ahead of time and also sort of form the basis of the presentation so the commissions can sort of agree with that material before it gets sent out, because I think we could send it out after our next meeting. That'd be a month's notice, and hopefully that'd be enough for people to come. Plus, they're probably listening right now. They're all listening, right? Everybody's listening right now. All right, any other comments or questions on that point? Commissioner Moore.
Well, I just echo what Judge Knudsen said. I really don't think this will be a productive process if it's just a repeat of, the public hearing. I think somehow we really need to make that clear that we're not interested in the, the opinions of people, but for the particular issues that we're dealing with here. Obviously, if people have solutions or ideas as to how we bridge the gap that we've got, that would be definitely interested in that. But on the kind of the broader issues, I think we have a pretty good sense of, where the lines are drawn. And so I'm supportive of this process. I think reaching out to the public is what we chose to do, and the stakeholders that have input, we need to hear from them. how we winnow those down to a core group is going to maybe be somewhat of the challenge. But Commissioner Schnell's idea, I think, is a good one to try to encourage people of like interest to maybe, sort of consolidate some of the involvement.
Yep. All right, sounds good. All right, that is the end of item 7. 8, if we could do 8 and 9, if people can stay for a little bit longer. Let's try to go through those.
Sounds good, Madam Chair. And I will say, and maybe it is because of the action at the legislature, we don't have that many people compared to recent meetings in the public attendance. But for those who are here, I have just activated your ability to raise your hand. And if you would like to make a public comment here in a couple of agenda items, which will be pretty quick, please indicate by raising your hand. And if a staff member who's attending would also raise her hand, so I can tell that the hand raising function is working. All right, so on the legislative update, pursuant to your vote at the last meeting, I did submit written testimony yesterday to the conference committee. Right now, the conference committee is on its the 3rd day of action, if action is the correct verb. I know I had to tune out a little early, so I don't know if Commissioner Schnell if anything happened at the end of the conference committee today, apparently not, but there was one vote, so they did agree on one policy item, but I heard a question today, but essentially the policies are very similar to what I talked to you about at the last meeting. So the House position and the Senate position, as I presented them to you at the last meeting, ended up being pretty close to what their ultimate policy positions are. And as you might recall from the last meeting, there's not a whole lot of overlap, at least in our areas, on those two policies. I did hear a very interesting question from Senator Bigham this morning, suggesting that it was important to do something this session. And the fact that she asked that question leads me to believe that perhaps she thinks there's a risk that nothing will happen this session. I will say we're getting very close to the line. My understanding is the legislature has to take final action by midnight on Sunday night, not this coming Sunday, but the Sunday following. And they're not going to be working, this conference committee is not going to be working Friday or Saturday due to a partisan convention. So there's a lot to do and not much time to do it. So we may have a lot of time on the June agenda that we didn't plan on if nothing actually gets passed. Because as far as I know, as I said before, nothing else has gotten enacted during the session. And the governor has indicated there will be no special session this year. So I don't think the commission has ever not published an August edition of the sentencing guidelines, but I'm not sure if there would be a reason to publish a new edition. I don't know.
They have to take the word "is" out. I mean.
Well, yeah, that's true. Okay, so
Come
we could publish the 22 edition to take out the word "is." All right. As far as the legislative update, don't have too much for you. We have sent out invitations to the NASC conference. I believe we have a pretty full vote. Madam Chair, in addition to you funding your own travel, somebody else has offered to fund that commission member's own transportation. We'll be picking up the hotel and conference fees, so that did allow us to invite another commission member. So we're going to have a pretty good turnout here. Based on my formula, I invite people based on how long they've been on the commission, but the primary factor is how long it's been since you were last invited to the NASC, National Association of Sentencing Commissions Conference. And so that works out to be where the new people on the commission get asked first. So and the other thing is, there is, as far as I know, one applicant, and I don't mean to disparage that applicant. I actually haven't looked at the application yet, but there's one applicant for the peace officer position. So I don't know if the governor's going to be okay just with that one applicant, or if the governor's going to wait for more people to apply. But if you happen to know anybody who's a peace officer, a licensed peace officer in the state of Minnesota who's interested in being on the Sentencing Guidelines Commission, it's not too late to get that application in. Madam Chair, that concludes my legislative and executive director's reports.
All right, any questions from anyone? All right, hearing none. Do you see, and so that we would be able to move to the public comment if anyone has any. I don't see anybody who's raised their hands, but I also don't see a staff member who's raised their hands.
It looks to me like Linda has raised her hand.
Oh.
That's what I'm getting.
Oh, yeah, now I see it. Okay, it was on the other panel for me.
For some reason, that coloring is very bad on my screen. It's like black on black, but I do see Linda's hand raised. I don't see anybody else's hand raised. So I'm going to unmute the caller. So there's a phone caller who's, let's see. Having a hard time getting the phone number. Okay, it looks like the phone number contains the digits 966. So I'm about to unmute you. If your phone number contains the digits 966, I'm going to ask you if you have any public comments to make. All right, I've unmuted you. Do you have any public comments to make?
Hi, this is Michelle Hipzag. No, I'm just listening at this time.
Okay, thank you. I didn't mean to put you on the spot, but I don't have any other way.
That's okay.
Okay, thank you. All right, so Madam Chair, it appears there's nobody who wishes to make a public comment.
All right. Any other issues or topics we need to discuss today? Okay, hearing none, then the meeting for today is adjourned and we'll see you in June.
Thank you.
Thank you.
Hi, everyone.
Bye-bye.
Bye.
Aye.